Welcome to the Akin podcast series, The Business Court Benches, Delaware and Texas Compared. This is episode 2, Home Court Advantage, Key Differences Between Delaware and Texas Laws Relevant to the Corporate Home Debate. I'm your co-host, Stephanie Lindemuth, a business litigation partner in Akin's New York office specializing in securities and fiduciary litigation.
And I'm Scott Barnard, your other co-host, a litigation partner in the Dallas office of Akin, specializing in securities and fiduciary litigation. Today, we're diving into the legislative changes and structural differences in corporate law that are heating up the competition between Delaware and Texas, with a particular focus on fiduciary duties, standards of review, and shareholder rights.
That's right. As we mentioned in our first episode, the competition has led to a fierce back and forth of amendments to each state's laws. Let's start with the basics of fiduciary duties. In Delaware, corporate directors must comply with the duty of care, the duty of loyalty, and the duty of oversight. Delaware allows director and officer exculpation for a duty of care breaches, but not for loyalty breaches. But what about in Texas, Scott?
Well, Stephanie, in Texas, corporate directors still must comply with the duties of care and loyalty and oversight. And Texas also allows directors to consider interests beyond long-term value maximization. These can be things like social purposes identified in certificates of formation. And like Delaware, Texas allows director exculpation for duty of care breaches, but not for duty of loyalty breaches. But Stephanie, what about Nevada? That's another option that a lot of times is considered by companies.
Yes, we definitely have to mention Nevada. Nevada offers the most extensive protection. It automatically exculpates director and officer liability for any fiduciary duty breach unless it involved intentional misconduct, fraud, or a knowing violation of the law. Nevada explicitly rejects any standard other than the business judgment rule, even for interested transactions. And this heavily underscores the perception that fiduciaries are less likely to be held liable under Nevada law.
Definitely. That level of protection is a major draw. But let's transition to the standards of review, which is where many of these recent high-profile disputes have originated.
Okay, let's start with Delaware. In Delaware, most business decisions are reviewed under the deferential business judgment standard, which protects directors from liability as long as decisions are made in good faith and with reasonable care. But Delaware also uses two other stricter standards. One is the enhanced scrutiny standard, and this intermediate standard is used for high-risk situations like a board adopting defensive measures in response to a takeover attempt, requiring the board to show reasonableness and proportionality in their actions. The second is the entire fairness review, which we've mentioned multiple times. This is the most demanding standard of review, and it's used when a majority of the board or a controlling stockholder poses a conflict of interest. Directors must prove the transaction was entirely fair by showing both a fair price and a fair process. We saw this standard used in the Tornetta case we discussed in our last episode.
Stephanie, how does the Texas approach to the business judgment rule compare to Delaware's, more flexible common law approach?
Well, in Texas, through their Senate Bill 29, which is dubbed the Dexit Bill, formally codified the business judgment rule. This provides a statutory safe harbor for directors if decisions are made in good faith, on an informed basis, in furtherance of corporate interests, and in obedience to law and governing documents.
I think that the Texas legislature's goal in codifying the rule, the business judgment rule that is, rather than relying solely on common law precedent like what we normally see in Delaware, is to try to increase predictability and consistency. The idea is that the presumption remains in favor of the directors and keeps the burden on the plaintiff. But this intentional approach is done to try to make Texas appear more business-friendly.
I think that's right, but I think there's also some critics of this as well.
Sure. There's some critics out there that worry that codifying the business judgment rule might actually create less predictability because while the courts can kind of respond to these changes in real time, the Texas legislature is only going to meet every 2 years.
Exactly. And this legislative move in Texas caused people to sit up and take notice in Delaware following the Match Group ruling. Delaware responded rapidly by drafting and signing Senate Bill 21 into law in March of 2025. This bill creates a safe harbor process for boards and limits shareholder access to corporate records, acting as a corporate shield to protect directors and controlling shareholders from litigation.
Stephanie, it seems like these legislative reactions have dramatically altered the litigation landscape, don't you think?
Oh, yes.
I mean, particularly when you think about like shareholder access to information, which in Delaware is the Section 220 request that we see, and derivative lawsuits. This is going to kind of change the landscape.
They certainly do. Both states are actively restricting shareholder information rights. Delaware's Senate Bill 21 significantly narrows the scope of records available for inspection under Section 220. It requires demands to be made in good faith and limits the inspection primarily to a set of formal corporate documents.
I think we're seeing similar changes with Texas's Senate Bill 29, which modified the corporate code to explicitly exclude informal communications from the definition of permissibly requested records. And that means things like emails, text messages, and social media are now off limits, unless the communication specifically, quote, effectuates an action by the corporation, end quote. I think we see the same with Delaware's law too, right?
Yes, Delaware's new law also excludes those emails and texts, generally requiring a showing of compelling need for materials outside the specific list of formal documents.
What about derivative lawsuits? What kind of changes have we seen in Delaware there?
When it comes to derivative lawsuits, Delaware does not impose statutory ownership thresholds for initiating proceedings, and it prohibits fee-shifting bylaws that would force an unsuccessful shareholder plaintiff to pay the corporation's legal fees. But I think Texas takes a different approach, doesn't it, Scott?
Yeah, I think that's right. The new Senate bill that we were talking about, Senate Bill 29, it allows publicly listed corporations in Texas to set a minimum ownership percentage. And that can be up to 3% of the ownership for shareholders in order to be able to file derivative suits. That's different from Delaware, and it provided that this stipulation has to be in the company's governing documents. And also, Texas is prohibiting the recovery of attorney's fees when a dispute is only resulting in additional or amended disclosures. The whole idea here being to try to deter these kind of non-substantive derivative lawsuits.
Right. And Texas, on top of that, introduced a novel protective mechanism in Senate Bill 29 regarding director independence. Public corporations can petition the Texas Business Court to assess the independence and disinterestedness of board committee members prior to a proposed transaction.
That's right. I mean, that's a big deal. This preemptive determination is different from the way it's done in Delaware, where a committee's independence is typically assessed after the fact during litigation.
Right.
Yeah, here in Texas, I mean, they're trying to do this on the front end to see if you can get the court to approve or rubber stamp, if you will, the committee before it does its work. But I think there are some questions about whether the courts can move fast enough in Texas to be able to give companies the approval they need in order to get a deal done.
Right. That preemptive process does raise concerns. Companies do worry about the possibility of judicial delay during tight transacting timelines and the risk of disclosing sensitive non-public information prematurely if they file such a petition. It's clear, though, that both states here, Delaware and Texas, are actively legislating to create a more attractive and, frankly, more protected environment for corporate fiduciaries in direct competition with each other.
So that wraps up our episode. We hope that you found it helpful. We've covered at kind of a high level the differences between Texas and Delaware statutory changes as well as fiduciary duty law. In our next and final episode, Texas Glitters, but Is It Gold? Assessing operational challenges Texas faces in achieving Delaware's gold standard, we're going to look at some of the operational realities of the new Texas business courts and the challenges that Texas faces as it tries to build a body of precedential law comparable to the decades of expertise that we find in the Delaware Court of Chancery. Thanks again for joining us. My name is Scott Barnard, your co-host, and I'm a fiduciary duty and securities litigation partner in the Dallas office of Akin.
And I'm your co-host, Stephanie Lindemuth, a business litigation partner focusing on securities and fiduciary litigation based in Akin's New York office. Thanks for listening, everybody. Until next time.